think that's what's going to happen. And again, it goes back to my point, which is they may have trouble figuring cause and manner of death, but they're not going to have trouble evaluating this sexual relationship. And juries do things all the time where they can say, I'll fudge on this one because I want to get this guy. Mark, David, the singer charged with Celeste Rivas's murder, is 21 years old. And I haven't really been thinking about this until this preliminary hearing. Do you think the DA is going to go for the death penalty?
I do not. I don't think the DA is going to go for the death penalty. And let me tell you why. This is so far, and if they, by the time this drops, my guess is that the prelim will be over. It's been an entirely circumstantial evidence case, number one. And number two, they have done very little, I think, to get over the hurdle of tying him to anything but the after the fact cover up. And
okay, well, let's talk about that. And I will say that if you listen to the testimony and if you listen to what prosecutors say they have, which is that Celeste was threatening via text to expose her sexual relationship with him and thereby destroying his career. And if you believe, and there seems to be evidence that he may have ordered an Uber for her to show up at his house the night she was last seen, and if you believe that because she was last seen then, and all of a sudden he starts ordering chainsaws and pieces of this pool where her body may have been dismembered are found in the remains of her body. And when you see a surveillance video of David parking his Tesla with presumably her body inside the last time it was ever moved, and then sat for more than a month, and then had 11 air fresheners inside of it, I know it's circumstantial, but that ain't just fringe stuff.
No, I don't disagree. However, there's a couple of things. Were the texts right in time or right prior to her last movements or sightings? Number one. Number two, do you have medical examiner testimony other than an answer that says possible, that whether or not the cutting was done before death? And do you have a manner and time of death other than possibly? And by the way, I've heard, and it's one of the things that's very irritating and understandable yet because we don't have cameras in the courtroom. If you're going to say chainsaws and cut up, that's great. But the evidence was, as far as I know, that the chainsaw had no DNA evidence on it whatsoever. Not blood, not fluid, nothing else. And if you're going to talk about some of the other items, if they are in unopened boxes, then that presents a problem as well. So I understand that the DA came out and the DA said, we got a lot more evidence, and the DA being Hochman, and this is just a prelim, and that is true. But let's make sure that we are focusing on what was actually proven.
And does it feel to you like they're presenting more evidence than they need to hold him over for trial? Because that's the way I've seen it. It almost feels like, this could have been so truncated. And I'm thinking, is the DA doing this just to make a point of what their case is about? Because it just feels like it's overkill in terms of making him stand for trial.
Let me tell you what I think. This case could have been done. I've talked to district attorneys, current district attorneys, former district attorneys. Could have been done in 2 hours.
Yeah.
There is a reason they're doing it over 4 or 5 days. They're doing it over 4 or 5 days, and this will betray my age. It's a old-fashioned dog and pony show, and they are emphasizing and leading with all of the gruesome, horrific details for 3 or 4 days, and they're ending with the medical examiner. Why are they doing that? Because if you look at the medical examiner's testimony, everything that we've talked about in the previous episodes, the medical examiner cannot say anything beyond possibility, speculative, maybe, could have been, and we don't have anything to a medical certainty. So why is that important? Because I guarantee you, absolutely, like death and taxes, the defense has got a forensic pathologist who is going to debunk all of these theories. So what the prosecution is doing is they're throwing out every kind of thing they can think of to basically preview the horrific nature of the aftermath, with one problem: they can't tell you what actually happened.
Yeah, but there are so many cases where you can't say what actually happened. In most cases, murders are committed in private, and yet lots of people get convicted. So, in terms of how it actually happened, um, I hate to bring up O.J. Simpson because he was acquitted, although it was a ridiculous acquittal. But, we didn't see it happen, but I know what happened. I'm not.
Understand, I'm not saying see what happened. What I'm saying is we know in O.J. Simpson from the autopsy, we know that there were knife wounds, that the and how many knife wounds, when it happened, and
We don't know.
obviously,
We don't know who got stabbed first. We don't know. He's saying it's a Colombian drug cartel who did it. I don't want to get into OJ, but what I'm
no, no,
saying is,
no. I'm saying what caused the death. You didn't listen, I guess, to the medical examiner yet, but we've got a little clip.
Hey, Mark and Harvey, it's Lauren from LA Magazine. Forgive any interruptions. I'm at LAX because I just left the courthouse where Deputy Medical Examiner Dr. Grant Ho finished his testimony, and I have quite a few things to say. Just overall here, I think a lot of us were waiting to hear about this potential rift that we thought possibly happened between the medical examiner's office, the LAPD, and the DA's office. We did not hear anything about that. The defense, specifically Marilyn Bednarski, asked Dr. Ho why it took him so long between September of 2025, when the autopsy was completed, to determine the cause and manner of death in December of 2025. Why did that take him so long? Well, he essentially just said he was waiting on toxicology. He knew what he thought he was going to determine the cause and manner of death as, but he just had to wait. And he said that's pretty standard.
You and I both know that the idea that there was no rift is,
well, we know there was a rift. We know that.
without a doubt. In fact, you don't have to rely on your sources. When you, by the way, you were early money on that. They took the unprecedented step of issuing press releases.
No, I get it. And look, I get it. And Mark, I hear you that I think, look, they're saying that she was stabbed. Stabbed in the abdomen. I get it. And there was another stab wound. That's what they're saying. I think that the defense can make real headway in blowing that up, and especially because it took them so long to establish cause and manner of death. I get it. But what I'm saying to you is, when you step back, do you necessarily need for a conviction to know precisely how the person did it and with what instrument? Because their point is David made more north of $13 million from Interscope in his music career. So he had a lot of money on the line. He could have made 19 million just off of that deal alone. And if it came out that he had a sexual relationship with Celeste, and that's something that they spent a lot of time with in this prelim, establishing that he knew she was 13 years old. He knew it. And they established that by showing contacts that the police had had with him when she was a runaway. So he knew she was 13, and she threatened to expose it. And had they done that, his career would have been over. So they are connecting dots. Do they need to say, and here's exactly how he murdered her?
I have two questions for you. Is that what's called motive?
Yes.
And is motive an element of the crime?
Yes.
It is not.
Well, I
Motive,
know it's not. Look,
it's not an
technically,
element of the
no,
crime.
but it's what every defense lawyer seizes on. There's what's
But
the
let me-
motive for them to kill somebody? But it matters to a jury.
it
It
does.
matters
However,
to a
you know what
jury.
matters more? Do you know what matters more to a jury? The stab wound that you just described. Let's accept the fact that there was a stab wound. Does it matter if the stab wound was when somebody was alive or when they were already dead?
Sure, it does.
Because if they can't prove that the wound, so-called wound, was prior to death, it's not murder by definition.
Okay, so let me ask you a question. Does a jury have to determine the precise manner of death in order to convict?
If the defense,
That's a yes or no.
yes, they do.
No, they don't. No, they don't.
Clearly, they would have to, because if she died and then the body was disposed of, then remember what you reported this. Remember what the LAPD said a month after this.
Can I just stop you for a minute?
Yes.
Have you heard of convictions with murder no body?
Yes.
By
In fact,
definition, there's no determination of manner of death, yet they still convict people.
Yes, but they have a presumption that there is a death, which they have to prove that was committed by.
She's in a Tesla without her arms and legs.
Well, I'll give you another example, which a guy who was convicted here but acquitted in Texas. Robert Durst was acquitted in Texas on the idea that he actually conceded that he did the killing, but that it was in self-defense and that he decapitated and cut up the body after the fact and was acquitted because
yes, but they bought a self-defense argument. David's not making a self-defense argument. Look,
yes, you know what David's making? The argument he's going to make, I'll predict it now, because the medical examiner has set it up. The medical examiner has not in any way testified to anything more than speculation, or it's possible, as to whether or not the stab wounds were before death or after. That is a significant, and you know what? I'll read the comments this week and I'll have people say, well, what about this? And what about the gruesome nature? Understand what the prosecution is doing. What they are doing here is they are painting a horrific picture, and they've done a wonderful job of painting a horrific picture. What they haven't done is shown that David killed her or that she was killed by
okay, so where you're going is something I thought about early on, before a lot of this came out, which is, what if Celeste Rivas went over to David's house, did drugs, had OD'd, and he's thinking, crap, this girl is in my home, died from the drugs I gave her, and I got to dispose of the body. And so he
got a $19 million contract.
I get it. Okay, so I get it, and that's a theory, and that's a theory, and I thought about that early on. But man, when you look at the threatening, exchanges about I'll expose you, and when you look at the sequence where she disappears, because it doesn't feel like she's coming over to his house to have a party. When you look at the backdrop,
it doesn't feel like that at all. And I will tell you that there is a compelling evidence of what the LAPD said a month after her disappearance and the finding. Do you remember? Because you reported it, you broke it. They said, LAPD said that we're not even sure a crime was committed other than a desecration of the corpse.
Right.
Do you remember that?
Right.
Okay. Now, that's a month after. You now have a medical examiner, and I think
but that was early on in the. I mean, that's what they should say. But that's what they should say. That's not a weakness. That's what law enforcement should say. Before they really get into the investigation. Of course, I mean, you would criticize. You would call it a rush to judgment if they had jumped to a conclusion at that point.
If they had said he did it. If they had said David did it, but it's not a rush to judgment to say that she was murdered or that we are investigating her murder. Remember what they said. They said, we're investigating whether a crime was committed other than mishandling of a corpse. That is a crime, but that is not causation for the death.
Again, I get it, and that's true. And yes, if there was nothing other than a body's in this Tesla and there's no backstory, I agree with you. But there's a huge backstory here.
They've shown a perfect, beyond a reasonable doubt, they've shown that he had every reason in the world to dispose of her remains.
And what about to kill her?
I don't know necessarily to kill her. I don't know that somebody who's 19 who doesn't have access to his money. And by the way, the motive, as we just established.
Wait a minute, that's really interesting you say that, because I know that a lot of the money came under the Coogan Law, which is a law in California that was established to protect child entertainers. But he was 19. So wouldn't he have had access to his money at that point? I think 18 is where the trigger is pulled.
Yeah, and there's also ones where the trigger can be delayed till 21. And I'm going to give you a little encyclopedic fact. Who is the Coogan Law named after?
Jackie Coogan.
And who was Jackie Coogan?
A child actor whose parents took all his money.
And was that during your childhood?
First of all, I'm not being interrogated here. If this is Jeopardy, I just won the round, dude. So let's move on.
Okay, you're going to tell
me. Why
do
you always?
Why do I go age? I don't know, because I
didn't invoke age like it's a bad thing.
Because often I think of this as two old angry men, and I have to remind myself it's just.
I don't think of myself as old. Okay.
That's why you look
even
so.
Though
young.
I am.
That's why you look so young and vibrant.
Even though I am. Okay.
Now wait. Can Branson play the rest of the next part of the clip?
And we can be no. Before you do.
Yeah.
So. This business about that they didn't talk about the dispute between the medical examiner and the police and the DA. I don't think that's going to ultimately matter. I think what's going to matter is there was a delay. I think it actually hurts the defense where the medical examiner says, no, there was no dispute. I had already made my mind up. I was just waiting for toxicology just to make sure. I think that is more hurtful to the defense than if if the medical examiner just couldn't figure it out. I think it actually helps the medical examiner that the DA they were doing this delay tactic. I think it works the exact opposite way.
This is where I disagree, because my feeling is when somebody denies the obvious, can you imagine the cross-examination?
Well, that's true. I buy that. I buy that. So listen, why are you dismissing the death penalty so quickly here?
Because the age, lack of criminal priors, the fact that it's LA County, and the fact that in California writ large, it's never going to be instituted. And I think it will in a case like this. I just think it will cause people to hesitate more than they normally would. And even though normally, or at least from a sociological standpoint, people who are okay with imposing the death penalty are generally more pro-prosecution. I think it backfires in a case like this.
So here's what I think. I think Beth Silverman, the prosecutor, and Nathan Hochman are going to sit down after the preliminary hearing and say, how confident are we of getting a conviction? And if they feel like they've got the goods, whether they do or not, but if they really feel that they have the goods, I think they're going to go for the death penalty.
I don't think so. I think Hochman is over the top sometimes, but that would be such a bridge too far. And I think he will understand that would be I think
a 19-year-old slaughtering. I'm not saying this happened, but I'm saying his argument is an adult slaughtering a 13-year-old girl with whom he had a long affair and cut her off so he could make money. I think that Nathan Hochman and Beth Silverman are going to look at this case long and hard and say, Do we feel like we can get a conviction? Are we really comfortable with it? If they're comfortable with it, I think they're going for it.
No, I can't imagine a case that would be made. I would love to, save the tape, as I always like to say. I
Well,
just can't imagine that they're ever going to ask for the death penalty in LA County, California, with a 19 or now 21-year-old in a case where they've got such, in my opinion, limited forensic information. And like I said, we're going to find that the defense
okay. So
has.
let me just make a further argument and I'll drop it. You and I know, both agree that this has been a publicity machine for the DA's office. That they submitted a brief that is never submitted in a case like this, laying out the facts, a brief for a preliminary hearing, which nobody does in a case like this. And it was a press release. And that's why they did that. They wanted to dirty him up. They wanted to show what they had. And there was no reason to file that brief. And they
Well, there
did.
was a reason. There was a reason to pollute
What?
the jury pool and to change public perception.
Well, okay, but it was a press release then, whichever
Correct.
way you slice
It was
it. So
manipulated.
if they are looking for if they are really looking for immediate advantage here, then and they want to show they're tough on crime, which Nathan Hochman has done from the day he announced he was running. I think this is shocking. It puts this case in a national spotlight in a way that it wouldn't be just if it was life without parole. And it wouldn't surprise me if he does it.
It would surprise me. So I think I think given the situation and who it is and the death penalty and all of the problems with the implementation of the death penalty, to two successive California Supreme Court justices talking about how in California the death penalty machinery is broken. It would be, I think, fly in the face of logic, rationality, and where this is and where society is.
Okay, so let me ask you something else. This is even tough to talk about, but she came from a troubled family and she was a runaway many times over and had not just run away, but had run away for long periods of time. And, you know, we all heard of kind of subtly putting the family on trial. Is that something that would be done in a case like that? And would it work or backfire?
So my guess is Branson's got the tape. I don't remember if Lauren talked about this, but I talked to her this morning and she said there was a suggestion through the cross-examination of the ME, the medical examiner. Did you talk to the family, to her family? Did you find out about her history? Did you, and started going down that road? I can see where that's headed.
Now, the defense also wanted to kind of point out, well, you don't know exactly who was holding the weapon, do you? And he said, no. They also wanted to point out the fact that he did not speak to Celeste's family to get any history that may be relevant to her cause of death. And I think what they were insinuating is, does Celeste have a history of suicidal tendencies?
I think that's weird that suicidal tendencies, she shows up at David's house and then disappears. She committed suicide at David's house.
What's weird about that? I mean, when you think about it, what's weird? It would not be the first time. I don't know about you reporting, but I will tell you as a lawyer defending, it would not be the first time. I can think of more than a handful of cases where somebody, and I don't have any information specifically to this case, but where somebody tried to commit suicide because they were upset. I remember a case 25 years ago I had that I tried in Pomona where that was exactly what ended up happening, where the woman was upset with her husband and tried to commit suicide. So that's not unheard of to me.
So the prosecution is alleging special circumstances here, lying in wait, which does have to do with, calling the Uber for her and allegedly killing her that night. Is that going to fly?
Well, the only way you get to the death penalty, to your point, is through a special circumstances. First, you've got to prove the murder. If you prove the murder, then you have to prove the special circumstance in order to get either life without parole and the death penalty. If you believe all of the things that you laid out or that the prosecution laid out that you're kind of positing here, then does that get to a special circumstance? Yes. I mean, that if they prove their case, that would get you to a special circumstance of lying in wait. I can't imagine literally a better prosecutorial blueprint for a special circumstance of lying in wait than somebody waiting at a house, sending an Uber, and having the victim delivered to them. That's almost like a law school hypothetical for a special.
There's a second special circumstance, which is killing a witness, and presumably this is a witness to a child sex offense, and that she was not just the victim, but obviously a witness to it, and they're alleging that as a special circumstance. Does that fly?
Well, I think that's got the same problem of most of these, where do they merge? And is there an argument that those crimes are one and the same and you're trying to split them up or serially prosecute? And that could end up being a punishment issue and not a conviction issue.
So does the defense try and argue there was no sexual relationship between David and Celeste?
I don't think they do. I think that to me would seem to fly in the face, to your point, of the text. I think that unless there's something in the discovery we're not aware of so far, and there certainly hasn't been any indication in the prelim if they have that, and maybe they're playing it close to the vest. But at this point, I think the battle is clearly on the cause and manner of death. I just think I've seen nothing over the course of 4 days that focuses on what the defense is going to focus on at trial, which is the manner and cause of death. And that's
and I will get back to the fact that cause and manner of death are not prerequisites to a murder conviction. And the reason I raised the sexual relationship is, as well as anybody, that you inflame a jury, and they're out for blood. And this is a way of inflaming the jury. And in this case, the judge is not going to rule that evidence overly prejudicial because it's central to the whole case. So the jury is going to hear it. And then the question is, the jury just going to want a pound of flesh when they go in the jury deliberation room?
Well, the proof of what you're saying in terms of inflaming the jury is, look what happened before and after the one court appearance where the DA got up, stood up in the courtroom, and said he had child porn on his phone. Not once, but twice. That turned the zeitgeist, if you will, on this case almost immediately. It didn't matter that whether the child porn related to her or whether it related to the underage nature of the relationship, 19 or 18 and 13. What it did was you waved the red flag of child porn, and that was all she wrote.
Well, what happens in this case?
Well, I think in this case, I think you're right. I don't think a judge doing what's called 352 analysis, which is the evidence code, saying more prejudicial than probative, they're going to say, yeah, it's prejudicial and it's probative, and I'm going to let it in.
Right. I mean, I think that's what's going to happen. And again, it goes back to my point, which is they may have trouble figuring cause and manner of death, but they're not going to have trouble evaluating this sexual relationship. And juries do things all the time where they can say, I'll fudge on this one because I want to get this guy.
I just think you're going to see, if you pick the right jury, and which is always the case. So I'm stating the obvious, but what will end up being the battlefield of this case is the prosecution's going to keep saying, horrific, horrific, horrific. Look over here. And the defense is going to be focused on where's the forensics? Show me the evidence. You've got to be logical. Hey, jurors, can you set aside all of this distraction? They're going to be arguing that that's all a distraction, that what you've got to focus on is the fact that they do not have anything other than speculation as to how this death was caused.
Okay, and then the final thing, there was a big deal made during the prelim with obviously no jury about whether he needed to be handcuffed and shackled. And the judge kind of split the difference and said no handcuffs, but still shackled. What do they do during the trial when a jury comes in?
When he's in trial, he'll be dressed in civilian clothes. They'll give him 3 or 4 outfits through the sheriff's department, and he most probably will be ankle shackled and not hand shackled.
Has that ever been a basis for reversal?
No, but you know what was a reversal is when they put one of the, remember down in Long Beach, they had the kind of shock collar on somebody in the.
Oh, right.
Remember that? 50,000 watts cursing through the accused body, and that was reversed. And I think the judge got sanctioned for that.
Okay, old man. See you next week.
See you.